also have an eminent discussant today to our panel, and that is Christian Sørensen. He is a legal scholar. He is a judge / chair at the Child Welfare Tribunal, which are making the decisions on child protection, removal or adoption, or kind of more kind of serious or intrusive interventions in the child protection system. He has also written extensively within child protection, or written about the European Court of Human Rights, and he is a really kind of sharp mind. He led also the expert report that made suggestions for new child protection legislation, which was published in 2016 and then have been ongoing and now really been enacted. And also wanted to say about Christian is that he has been a keen kind of fighter for children's rights and children's participation. And this is as a very difficult right to implement, and he has been in the forefront for this. So we also will bring you up here. We will start out with Hege. You will have up to 10 minutes.
For this introduction, and I want to start by saying thank you to Marit and Siri for editing this book together with me. My first time, and it was, it's been a privilege. And thanks also to the authors, some of them who are here. That has also been a privilege, and also because it's, which is also now represented, the different, it's truly been an interdisciplinary book, and also with Neil, who has, as Gus says, does scary stuff down in Brussels, or at least studies scary stuff. And yes, so, but the book. So why did we do this? What kind of motivated us and made us sit down and put this all together? So as you now have heard a little bit about, and as some of you probably know, the Norwegian Child Protection has been under massive scrutiny of the European Court of Human Rights in the last 10 years. So it started actually quite slowly back in 2013-ish, when the court then started admitting the first cases of this kind of group of cases. And then parents were claiming that the Norwegian state had violated their right to family life under Article 8 when they had, in most cases, removed children from the home. And then in 2017, we got the first decision in this group of cases. And that was actually, to perhaps someone's surprise, that was actually a non-violation. So this was Strandlobben, the first decision. But then this case was brought into the highest level of the court, so the Grand Chamber, and then it just exploded. So 2 years later, in 2019, the court found, so this is Norwegian, but it says Norway is found guilty of violating human rights. And this is Trude Strandlobben. And so at the end of 2024, the court had admitted 80 cases concerning Norway. So it should be said that I think 49 of them are dismissed, so not given a decision or a judgment on merits, but 23 of them have actually ended with a violation of human rights. And at the same time, and starting even before this, it was, let me see if I'm, yes. There had been worldwide demonstration against Norwegian Child Protection, and anti-liberal movements had targeted the system and more broadly also the Nordic welfare state through largely organized campaigns and protests. So naturally we were a bit stunned about this, so mostly because it's such an unprecedented number. And this backlash was intense. So what happened, and what was kind of the context of all of this happening, and what happens now? And so the first kind of thing we started with was that this attention from the court is kind of, and the Norwegian case, it's a paradox. I forgot some pictures. Gestapo, yeah. So the Norwegian paradox. How is it that Norway, which is considered a high-performing welfare state democracy, leading in child protection or child rights protection, and then also consistently ranked high on indexes measuring the rule of law, child well-being, and so on and so on, we're now facing this massive critique. And another unique aspect of this group of cases was that it was also getting a lot of attention from third parties. So in the cases that we saw that were being brought to the court, they were attracting a lot of attention. So not only from organizations such as that on the screen, so Ordo Juris, which Neil knows a lot about, but also from other member states of the European Convention on Human Rights. So they were intervening and wanting to have a say in these cases. And that is, as some chapters in this book point to, unique, actually. And yes, so and all of this is happening in a time where the court is becoming increasingly important, but also increasingly contested, and also where anti-liberal, so this is, what's her name, the English? Yes, yes. So England, for example, has threatened to leave several times. And Neil, you also know this very well, the report here. So there was also this general spread of anti-liberal backlash against minority groups, such as children spreading. So we wanted to kind of dig in and explore the dynamics surrounding the events that we were seeing and look at the court, what the court was actually doing, who was getting involved in litigation, and what happens when the court scrutinizes one country like this. So in addition to kind of the more general critique that the court has gotten from Theresa May and others like her, they've also received criticism for not paying enough attention to children's rights. And just when scholars kind of started to see a change in this, so the court was paying a bit more attention to children's rights and kind of emphasizing their interest, then some say, or many say, that development halted with the Strandlobben judgment. So with this judgment, the court is said to kind of move away from previous precedent, putting emphasis on children's interest and rights and centering them at the decision. So this has by many been seen as a setback for children's rights. And so we were also curious to see what kind of potential lies in the court as an institution that advances children's rights. Yes, and all this is very interesting, right? And at least we thought that. So we gathered a group of the best people we know to write this book. And so there are, where am I? Yes, 13 chapters that in some way or another focuses on the interconnection of the European Court of Human Rights, child rights, or child protection. And I'm probably already nearing my time, but the book has, I'm going to go quickly through them so I can do some of the concluding remarks. We have three kind of main bulks. So the first one is looking at the European Court of Human Rights from more of a national perspective. These focus either on the Norwegian case and the decision making made in the court, and looking at if this was actually unique, what we were seeing, the scrutiny towards Norway, and spoiler, it is. And there are also some implications on studies on the implications at the national level in Norway, but then also a very good chapter in Finland, which we will hear more about. And then there is the next section, which is more on the transnational influence of the European Court of Human Rights. And here the authors seek to understand the more international drivers and influences that shape the court's practice. So here we have these guys, for example, so they can tell you more about what they did. And then in the last section, there are some 3 chapters that look at the court's jurisprudence on child rights and child protection at a more general level, looking at how the court's normative underpinnings and interpretations of important concepts and rights. And then the last chapter concludes that, as I mentioned, that the CRC is an important legal source for the court, but then that it is superficial. And that's kind of where we start up our conclusion. So one of the main questions that we raise in our concluding chapter is if the court is an untapped source for advancing children's rights. So while some of the studies in the book do say that they find some potential in advancing some rights such as identity rights and anti-discrimination, the overall picture from the chapters is that it's rather bleak, and that the court seems to be shifting towards a parent-oriented focus, and at least that the consequences of their jurisprudence is more parent-oriented policies and practice. I also want to give like a small to the others coming here. So it's also we see that there is that the court is also becoming like an ideological battleground where children's rights are now increasingly used in more kind of transnational battles of ideology. And yes, I think I have to stop.
Okay,
yes.
Thank you so much, Hege. Super good. Okay, so just quickly then transit over to Tarja, and then you will present from your chapter.
Chapter 3.
Chapter 3.
Which I heard is from the national description section.
Yes.
You described that part. So this is a chapter which was written by Raija Huhtanen, professor of public law, and by myself. That is right to respect for private and family life. In the period of 1959 and 2023, and we also try to capture the influences of the judgment on Finnish child welfare. So the data for our analysis was, of course, the judgments and the impact on the preparatory works of child welfare legislation in Finland, Supreme Administrative Court decisions, and also national policy programs, reform programs of child welfare, which have been quite multiple in the latest 10-15 years. Basically, it's textual analysis. And what we found in terms of judgments is 4 judgments only. or how should one say it? And they are all given in the period of 2001 and 2006. And they were all, in simple terms, about the same issues. They were about the violations of the duration of the placement and termination of care. That the cases, in those cases, children remained in the care without constant assessment, and they were not unified with their parents. Of course, if you go into the legal issues, they are much more complicated, but let's keep it simple here, especially because I'm the one presenting it. And we can see very direct influence of these judgments on Finnish Child Welfare Act, because the act was reformed in 2007. The judgments were given when the previous Child Welfare Act was valid. So when this new act was reformed, they very carefully considered the judgments. And if you look at the preparatory works, there are often references to the Convention and Article 8 and the judgments. And this resulted in the law, so in the present Child Welfare Act, so that there's plenty of procedural norms how to consider the termination and duration of the care. Family reunification is the main aim, and contact should be constant, and so on and so on. But we also realized that there are indirect influences when we looked at the policy programs, reform programs, national programs, which I said that there have been plenty of them. We looked how much they reference to the European Court, the decisions of Article 8. We realized that they very rarely referenced the European Court of Human Rights. They more reference to the CRC. But they discussed a lot about the topic, what the judgments were about. And even in the first national policy program, 2013, they widely discussed the somehow implications of the judgments and suggested that nevertheless we should have permanent placements in Finland. That was the proposal given that time. But when you follow up that suggestion in the later policy programs, they all say that that would be against the human rights conventions and that suggestion shouldn't be taken any further. Which we think that in this non-legal arena, the judgments are misinterpreted. They are not somehow, that's not the message what the judgments have, but it's a very strong consensus that we shouldn't have permanent placements because they are against the human rights as seen in the present system. And at the moment we have children, especially those ones who need long-term care, they live in some kind of limbo because there isn't any stable family reunification, even though we have these somehow new procedures, and they shift between many families and many homes. So if you mentioned paradox in your presentation, I think we have a paradox here as well. But that's more in the chapter. Thank you.
Perfect. Okay. Super. Thank you so much, Tara. This was excellent. Then we're moving over to Oscar. Yes. Are you ready to give us a little bit on the amicus briefs? The bad ones, or?
Yeah, the bad ones. I'm going to speak prior to Neil, so this is good. Then I don't get nervous. All right, so let me take you straight into the problem. The European Court of Human Rights is built on a beautiful paradox. It must enforce a common European standard of human rights, while simultaneously respecting that each member state has its own democratic traditions, legal orders and sensitivities, cultural variation and so forth. The doctrinal tool for handling this tension is what we call the margin of appreciation, a flexible space where the court says to each member country, you know your society is the best, but we are watching. It's a supervisory court in that sense. Now, flexibility is both a strength and a weakness. It allows for human rights to adapt to pluralism, but it also opens the door for manipulation. Now enter here the amicus curiae, or friend of the court, or the third-party intervention, which is a built-in mechanism. Many amici are genuine, providing expertise, well needed, and they do need it, and perspectives. But some are what I call bad amici. They are less friends of the court and more like that friend who insists on giving you financial advice after 3 glasses of wine. They can carry strong interests, have very, very polished arguments, and they try to lobby the court into bending human rights in their preferred direction, even away from the cosmopolitan ethos that animates any human rights instrument. The key case to illustrate here is the one that Hege mentioned, the Strandlobben v. Norway. Here, an American NGO, Alliance Defending Freedom International, he's nodding, filed an amicus brief arguing that biological family bonds should be prioritized and aim to ensure reunification unless there is clear evidence of danger All right? That might sound noble until you realize in practice it could legitimize leaving children in violent homes, so long as biology was respected and the child was not in clear danger, which is not the same as risk, for instance. Norway lost the case, and now did the amicus sway the judges? We don't know. And it is of less importance, actually. The point is that their friendly advice is used to argue the case for why Norway should lose the case. The point is the clear-cut risk the court meets. The margin of appreciation, when pushed by bad amicus, or bad friends, can be used to dilute human rights and make them mean something else. So how do we defend against this? That's where legal theory comes in my opinion. And in this chapter in the book, I stage a duel between two positions, legal positivism and discourse theory. And know also that other legal theories would produce even other duels and other outcomes. So the point is that they are very different and they are very widespread. Positivism insists on the separation of law and morality. For the positivist judge, the margin of appreciation functions as a doctrinal bridge. It secures respect for national sovereignty while tying states to the convention, to the degree the country has codified the convention. Human rights here are binding, not because they are good or just, but because they are codified, backed by authority and command obedience by citizens. In practice, this makes the margin a technical device for deference, giving national legal orders space so long as they can point to a valid rule. Its strength is discipline, with moral rhetoric, or with an amicus brief with moral rhetoric that lacks legal foundation, it becomes irrelevant. But the weakness is also clear. If a state gradually rewrites its laws to reflect practices that corrode dignity, the protection of dignity, a positivist approach to the margin risks legitimizing them. Bad amicus know this and can play the long game, supporting incremental legal changes until their agenda becomes part of ordinary law. Now, discourse theory begins elsewhere. The margin of appreciation becomes not a license for national variation, but a deliberative space. Judgment is legitimate only if all those affected could accept it as an outcome of rational deliberation. Judicial reasoning must therefore be transparent and inclusive, treating citizens as potential co-authors of the law. Rights, in this view, do not shift with location depending on who claims them or what country it comes from. They are anchored in the universal experience of violation of dignity. The margin can clarify rights under new conditions, but it cannot justify practices that fail the rules of discourse. Bad amicus may try to narrow human rights to parochial interests, yet their claims collapse if they cannot be defended in terms of dignity and equal respect for all, which is kind of pillars of human rights. So what do we learn? First, the margin of appreciation is not a single doctrine. It lives differently under different legal theories and the judges and practitioners of law. Second, the danger of bad amicus is real. We will hear this. They exploit precisely the court's openness that this margin provides, its willingness to hear friends of the court. And finally, the takedown. Human rights jurisprudence cannot rest on a claim that a doctrine is neutral. It requires a conscious theoretical orientation. Without it, the court risks being tossed around by lobbying winds, sometimes from well-intended actors, but sometimes from wolves in sheep's clothing, our bad friends.
Okay. Thank you. Super interesting. And then I just swiftly hand it over to Neil.
Thank you. In fact, I think that was perfect. You just ended with wolves in sheep's clothing, and now it's my turn. So I'll get to discuss a little bit more about who these wolves are.
Ooh, okay.
So that's perfect. First, I just want to thank Siri, Marit, and Hege for the opportunity to contribute to this. I think it was really a nice example of the Bergen Exchanges, because I don't know very much about children's rights, but I do know about these anti-rights actors, and I think this was a good marriage that can be produced out of these exchanges. So I took a look a little bit at these bad faith actors getting involved in the contestation around children's rights, as has been mentioned. And I found it interesting that you mentioned that it started in 2013, all these cases, which corresponds to when the anti-gender movement in Europe really got organized. And so some of the things I looked at are, first I scanned to see what has been said about these. And what I found is that there's a blind spot. On the one hand, the people involved in children's rights are not necessarily familiar with the actors involved in contestation in the traditional sexual reproductive health and rights LGBT issues. And so when it started happening to them, they didn't really understand what was happening. Then separately, those who know what is happening, those involved in women's rights, abortion rights, LGBT, they're not looking at children's rights. That's not their issue. So you have this blind spot coming from two different sides. And so then I took a look at what are the anti-gender actors saying or doing about children's rights. First, you find that they're all active on this in some way, but in the areas that they're used to becoming involved in. For example, they don't like comprehensive sexuality education. They want to protect the unborn child and things like this. But their involvement in child protection cases is relatively new. I think another component to consider is the very nature of child protection cases, which lend themselves to disinformation. Because you're basically talking about cases when a state may intervene within a family and take a child out of that family into protective services. Okay, and now that by itself is a judgment call, because if the state acts well, then it does it before there's actual harm to a child. But also from the perspective of communications and media, it sets up an ideal case of a David and Goliath scenario, where you have the poor little family having to resist the overbearing long arm of the state that intervenes in this sacred space that is the family. So it lends itself very well to disinformation, which is why also it's even the NATO came out with a report that pointed out that Russian disinformation targets Nordic countries, gender, and child protection services among its areas of disinformation. So if the Russians are doing it, it shows it's useful. Okay? But then also a lot of the Christian right, anti-rights actors are doing this, are joining the party. Now, what is the motivation for these anti-rights actors to do this? Basically, we can sum up the anti-rights motivation in most of their advocacy, most of their approaches, as targeting three main objectives. One is the protection of life from the moment of conception until natural death. Another one is the protection of the family, heterosexual, patriarchal, traditional family. And another one is the protection of freedom, specifically religious freedom and the freedom of speech. When we take a look at their involvement in children's rights issues, it touches upon the protection of the family and the protection of religious freedom, because they will often argue their claims that it's their right to raise their child as they want according to their religious beliefs. Now, what we saw is that while all anti-gender actors are involved in some way on children's rights, there's really maybe 4 of them, which Rachel Chichowski, who wrote another chapter there, calls repeat players. Or as I often mistake it, I call them repeat offenders. But there's 4 of them. 2 of them have already been mentioned: Alliance Defending Freedom, Ordo Juris from Poland, the European Center for Law and Justice, and Citizen Go. They are involved in different ways, but the ones who really get involved in the litigation before the court are Alliance Defending Freedom, a U.S. Christian right group. They're not just any U.S. Christian right group. They're the ones that brought the Dobbs case to the U.S. Supreme Court and overturned abortion rights in the U.S. So that's who we're dealing with in these cases. And Ordo Juris is an extremely colorful group coming from Poland. There's separate reports on them, which I'll invite you to take a look at. But in the time span of the article, we were able to see that they were involved in at least 8 cases before the European Court of Human Rights. Now, we're not too sure whether they were able to have influence or not, but I think going back to what Nina was saying on Tuesday, what we saw is that they were able to influence soft laws, which then may influence the court. And one very practical example is a report from the Parliamentary Assembly of the Council of Europe dating to 2018, entitled Striking the Balance Between the Best Interests of the Child and the Needs to Keep Families Together. And now if we take a look at how this report came about, we can see that it originated in the Bodnariu case, which was a Romanian family here in Norway. The Child Protection Services were involved. And because it involves a foreign family, then it has an international dimension. And so we saw Romanian members of parliament at the Council of Europe Parliamentary Assembly take the issue up. Norway's a bad guy. We need to protect the Romanians. This was then taken up for work by the Parliamentary Assembly by a Moldovan member of parliament from the center-right EPP group. It then became a report at the Council of Europe. This Moldovan member of parliament was himself part of many international networks, all associated with the Christian right. And so they were able to organize visits to Norway. The people that they visited in Norway was a Reverend Jan Eger Toth, which I think the Norwegians will recognize as being a charismatic but not necessarily influential person who is very much against the Norwegian state intervention in this area. That served as the basis for evidence into the Council of Europe report, which was then supported by other members of parliament from Christian rights circles, and it was eventually adopted. All of this taking place while there were progressive actors active at the Council of Europe, but they were not looking at children's rights, so it sort of slipped under the radar, and then it was able to produce this report. And some of the other actors contributing to this report were Alliance Defending Freedom, Ordo Juris, European Center for Law and Justice, all of this with the communications efforts of Citizen Go, a social media platform, Christian right one, based in Madrid. So just to conclude here, so we have evidence of the anti-gender actors being very much involved in this, getting involved in high levels of advocacy in this. And then maybe just to finalize, we can see that Alliance Defending Freedom, they've come out with a series of documents that highlight what one of their new priority areas will be, and that is parental rights. So this will affect child protection and a whole range of other things. Ordo Juris is also involved in this. They were able to, they acted as the legal representatives of the first Norwegian to ever be granted asylum in Poland because she was fleeing the Norwegian Child Protection Services. So we can see that they have influence, they are ambitious, but we need to, it's not clear yet whether they have influence at the court. But I think we all need to factor into the equation that these guys are involved in this, and as Oscar said, they don't necessarily have the best interests of the child at heart. Thank you.
Thank you. Thank you so much, Neil. Christian, now I'm going to hand it over to you to being the discussant here, and 6, 7, 8 minutes.
Okay.
Is that okay?
Perfect.
Yeah.
Thank you so much for inviting me. Do you hear me? Yes. It's almost mind-blowing to hear you speak about all these interventions. And thank you so much for inviting me to this event. It's been very interesting to be here. I must admit that I am a bit on uncertain ground when commenting on contribution from distinguished social scientists. I have a legal background myself, but I will do my best. Hopefully I can contribute to some fruitful conversations. For each presentations, I will make a comment and pose a question as I was asked, and I also try to connect parts of my reflections to the Strand-Lobben judgment, which is a major backdrop for this book. And first to Hege and Marit. Let me start with perhaps my greatest disappointment as a citizen and as a human rights lawyer, namely that liberal democracy was not, after all, the end of history, as Fukuyama proposed. Thank you. It's important to remember, I think, that the international human rights system and international children's rights in particular were developed in a moment of optimism and a shared belief in liberal democracy and all the values which follows. And children's rights have found its way into the European Court and the European Convention of Human Rights through a so-called evolutive interpretation, like a dynamic legal interpretation. And that's, of course, easy if we have with all judges have the same belief in the same values. But the book which you have written shows us that the context today is quite different. We live in a paradigm marked by post-modernity, where facts and truth dissolve, and by populist challenges to the liberal order from authoritarian and conservative forces. So I think this book is really valuable to understand the challenges the court faces in this environment. And the book, for me at least, makes it clear that the project of evolutive interpretation for children's rights in this field of law is no longer straightforward. So, and I also want to, this is, I think is important to state this, and I think my next point is, I want to, in a general level, is to point out that there is different views on whether Strand-Lobben represents, strictly legally speaking, represent backsliding of children's rights in the law of the European Court of Human Rights. I think you, Tarja, you touched upon that. I would just want to say a few words on that, because the court's reasoning is not always consistent, and in its reasoning, and the different formulations are not always the best, and this opens the door also for misinterpretations. For example, in the Strand-Lobben case, the criticism of Norwegian authorities for focusing too much on the best interest of the child, which is hard to accept as a statement, in my point of view, was reality a critique of the government's failure to consider any possibility of family reunification after a care order. So this is the key point, I think, as the same as in Finland. The lack of thinking of reunification after a children is taken into care. But I think it's also important to say that Strand-Lobben said, and this is important, the child best interests are of paramount importance, and in cases involving care of children and contact restriction, the child interest must come before all other considerations. And this is also a principle which the court says in almost every, not maybe all, every cases, but most of them, I think. So I think an important consequence of the Strand-Lobben group of cases is not only strictly legal, but also discursive. Much depends on how judgments are spoken about and which narrative prevail. I fear myself that ultra-conservative states and pressure groups alike claim support from court in ways that are not supported by its case law. For me, that's important to say. And my question to Hege and you, Marit, is what do you see as the greatest obstacle to promoting children's rights within the European Court today? Is it the court system itself? Is it principles, legal principles? Is it lack of representation of the children, which is a big lacuna, as you know? Or is it third-party intervention or something else? Yeah, time is flying. My second comment goes to Tarja. Given the attention Strand-Lobben has received in Norway, I was surprised that no study, I have read a draft of your and everyone's chapters. You write that no study yet had been conducted in Finland regarding the consequences of the 2000 judgments in the European Court into Finnish child welfare system. That was quite surprising for me, because in Norway has been a lot of writing about that, and yeah, a lot of attentions. Well, yeah, we have, of course, even more judgment against us, but I have been wondering what have the consequences in Finland been. So thank you for writing this chapter. I think it was really enlightening. And I found it interesting to see many of the same developments in Finland and in Norway stemming directly from the court judgments, especially around the long-term out-of-home placement. In both countries, child protection has moved towards treating out-of-home placement as more temporary measures, or maybe only in Finland. But also in Norway, they are more considered more as temporary. Before the Strandlobben case, that was very seldom. So I will underline that the principle of the court do not prevent long-term placement or even adoption when that's necessary. And unlike Finland, as you said, in Norway, the Supreme Court and the legislature have taken significant steps to strengthen the stability for children in foster care. Much thanks to also Marit and her distinguished expert group who delivered a report on this issue some years ago. So my question to you, Tarja, what I was thinking about when I read your chapter was, have there been any discussion around contact visitation or the level of contact between parents and the child after a child is taken into care? Because this is a huge, at least for the practitioners in the tribunals and in the courts, it's quite difficult to handle. We have seen an increase in the contact level in Norway from before the Strandlobben case, from 3 to 6 contacts yearly, and to now we see 12 and even more. That's the normal level. Yes. So Neil, I take follow the book chronology. So yeah, your chapter made a strong impression, as I already have said. I was aware that ultra-conservative actors were engaged within the European Court of Human Rights, but I didn't know much about them, to be honest, and certainly not that anti-gender contestation was a part of it. So that was quite that was new for me. So disinformation campaigns clearly challenges the human rights systems. I think also the UN system of human rights. As I understand it, you haven't done research on whether such campaigns have influenced the reasoning of the court. I think this is a future research question that stands out. I think it's important. We see some direct influence in typical dissenting judges' reasoning from the European Court of Human Rights. And one example is from the Strandlobben case, the Judge Kuris, who had directly linked to the third-party interveners in his very critical reasoning. So I don't know if you can answer, Neil, but my question to you is, what do you think is the most important means for the court in dealing with a disinformation universe? It's a big question, but you have probably given some thought about it. So my last comment goes to Asgeir. I share your interest in the marginal appreciation doctrine. I've done some legal research on that myself several years back, but this doctrine has been described as slippery and elusive as an eel. So I think that's in a way quite, you know, so that's not too bad to call it this way. So it's not hard to follow your concern. I do not disagree that a more solid theoretical foundation could make the doctrine more resistant towards manipulation, as you propose. But I think maybe this is difficult considering the different legal cultures among the judges in the court. However, I think it's important to note that the doctrine of the marginal appreciation often has been seen not as an obstacle, but as a tool to strengthen effective child protection under Article 8. For example, in her PhD dissertation, Trude Haugli, she argued that the margin should be wider for states when deciding on contact regimes, precisely so states as Norway could prioritize the best interest of the child and children's rights over the family. And the same logic applies to out-of-home decisions in the court reasoning. And actually in the Stanloven court, the Norwegian government argued for a wide margin of appreciation as they received in the chamber judgment. But the majority of the Grand Chamber did not agree and narrowed the margin. So my point is that the margin has often been seen as a vehicle for advancing children's rights in child protection cases. I don't think you disagree about that, but I think it's important to state that. So my question to you, Oskar, is how can the court establish a more theoretical foundation for its decision making, and do you think one particular theory stands out? Yeah.
Fantastic. Thank you so much, Christian. And there's tons of work behind this as well. So because you have actually read it. So thank you. We are opening up for questions, and then so I am now assuming that Tarja, Hege, and Neil and Asker, they will remember the questions.
So I wanted to pick up on the question from you, because I think that's an important one to start with, because we are in no way saying that there aren't flaws with the Norwegian child protection system, because there obviously is. And we all know this, you know this. And the critique is legitimate in many ways, but that's kind of not the point. So the point is the Norwegian paradox, as we started off with. So we have this state who's on paper good at protecting children. They're doing well on the rule of law. So why is this happening? So we're looking broader and kind of into what's going on in a more, in a larger context, and what's going on. And then also looking at the implications of the court's jurisprudence. There are some things that we can say is perhaps not as good. And then there are the influences from parties that perhaps shouldn't have such an influence on these things, but that we don't know how much influence they actually have, which we also think is a very, to point to your, what you point out as a next research question, which we also pointed out ourselves, because we think that is one of the most, what's going on in court is non-transparent at all. So there are so many things we don't know about how they use their discretion, how they actually are influenced by these things, how they decide who's allowed to intervene, and so on and so on. And also with the ideological battleground, yes, of course, that's kind of why they're there. But it's meant to address, firstly, for children's rights, as both Neil and Asker illustrate very well. But then there's also the point that these cases are actually seen to attract more kind of ideological battles, or kind of because they attract so much attention from these NGOs and these organizations and movements and the member states. And that is one of the chapters actually looked into this. So. And it is actually quite unique. So I think it's mentioned that the other cases who attract that kind of attention from other member states is the Russia-Ukraine conflict. So that kind of sits it in the context of that this is actually something at a higher level of kind of attention in that sense. Yeah.
Super.
Long answer.
No, you needed to do that. So super good. Thank you for that, Tarja.
Thank you. I think it's Kristin, you asked about the impact of the judgments on the contact arrangements in Finland, and indeed it was one of the implications of the judgments that the present act includes constant contacts between parents and children. So it's taken for granted that even when the child is separated from their parents, the contact will remain, and it can be even weekly if it's so decided. And that connects with Stefan's last point, that the procedures are such that it's somehow when the permanent placements are rejected, so it still means for children in care that they are constantly assessed whether the placement will continue or not. And it's pretty tough if it happens for 4 or 5 years, that you are always on the thin ice whether you will be united with your parents or not, especially when we know that the numbers are such that it's just roughly 6% nowadays of children who are united with their parents before they get 18. But still the procedures take place. That was all.
That was it. Okay, thank you.
Yeah. The margin of appreciation and bad friends. Well, the margin is it's one of those inventions that are really ingenious, and we had to have it, and we need to have it, and it will forever be there. And that has to do with all these jurisdictions being so different. So we need to have, on a supranational level, some form of mechanism that kind of speaks to each and every legal culture. So that needs to be there. But knowing that we have now a trend, let's call it that, of courtroom lobbying, and that you have NGOs that are staffed with lawyers that really knows the system and how to push it and put their finger in to kind of tilt it gradually, it makes the margin of appreciation into a mechanism that can be exploited, hence the weaponization metaphor. Because I deleted that from my lecture manuscript because I can't say that out loud. But yeah, I agree with you. So it is indeed weaponized because it allows for instance, orders to develop amicus briefs. They don't even need to be part of the judgment. It just needs to be out there to say that this is our opinion about the case, and their job is done. So, because nobody's going on Hudok to see the amount of influence that Alliance Defending Freedom is, well, some does, but not the populace in and of itself. So they are doing this to kind of corrode the ethos of human rights, in my opinion, because they don't like it. And, well, we are living in a post-liberal world, I've been told by the Vice President of the US, so I disagree, at least for now. So over to you, how do we solve this kind of dilemma? Because you need the margin of appreciation, but you also need to understand how you confront it. And I do think that how you talk, because we do have judges coming from different cultures. Yes, we do, because we educate differently and we read different books, and they are really important. So it kind of speaks to the professionalization of the legal profession in and of itself. There are variations in schools in Norway, but Norway to Sweden is different, Norway to Germany, so we're not the same. But if you're a judge on a that's going to lead Europe on human rights issues and justify judgments on a supranational level with a human rights instrument, you need to lean into what that means. And so that kind of approach to legal theory needs to be able to enforce the point and purpose of having human rights. And to me, my go-to place is Article 1 of the Universal Declaration. And because it's brilliant, it's very easy, but it has to do with protecting the dignity of the person. It's simple. It's very hard to do it. But if you, for instance, lean too heavily into a positivist approach to law, you don't care about the legitimacy claim of human rights, which is kind of what it depends on. That it's more correct to protect the dignity of a person than to allow for a society to give birth to a new era of Nazism, for instance, which gave birth to this idea of protecting the dignity of each person. Yeah.
Okay, thank you so much, Oscar. Neil, then you will have all the questions to you, please.
Thank you. And thank you for the comments. A few thoughts came to mind. I think your comments about how can the court or the judges be prepared for this disinformation around them, and then also related to Namita's question, have these actors had an influence on the courts and on the judgments? What I've been able to see is that it's not clear that they have had any influence on the actual judgments, but we can see that these actors are trying to influence the courts in the long term. Okay, so as Asghar said, they come out with amicus briefs. It doesn't matter whether they have any impact or not. Okay, so they're there for show. Okay, and then they meet other objectives such as fundraising. Look, we're active at the courts. We're serious people, etc. Okay, usually I haven't seen that these amicus briefs get anywhere. Then it feeds into another objective of theirs. They can go on and say, look, the courts always have it against us, the Christians. Okay, they don't take into account the valid critiques of us faithful people, and then we see another aspect where they try to delegitimize the court and the judges themselves. So that one of these actors, the European Centre for Law and Justice, came out with a report whereby they prove that all of the judges on the court are agents of Soros. Okay. And this then has an impact on the court and on the Parliamentary Assembly. And then we can see most recently, this happened just this summer, some of these actors try to influence the nomination to the judges to the courts. So that in Germany, if any of you followed, there was one candidate to the Bundesverfassungsgericht, the German Supreme Court, Brosius Gersdorf, who became the subject of a virulent far-right disinformation campaign, led by Citizen Go and other actors close to the AfD. And last I checked, before coming here, she had just withdrawn her candidacy because of this disinformation campaign. So we can see that this is part of a continuum of trying to influence the overall composition of the court. Then another point about the validity of the critique of the Norwegian Child Protection Service. I don't know, have you seen Mrs. Chatterjee versus Norway? Yes, okay, yeah. So there was a Bollywood film about this, okay, a good one too. So there is critique within Norway about this issue. Okay, so that's as there would be about anything. We're in a pluralist democratic society. I think also two other things which need to be considered, and please correct me, Hege, Marit, if I'm wrong, but the Norwegian child protection system is very advanced and rather unique compared to many other countries. And so when migrants come here to Norway, their notion of what child protection may mean in Norway may not correspond to what it is that they knew in their own country. So there's a discrepancy there, okay? And then the fact that it applies to migrants, they may feel that they are being specifically targeted, whereas it may not be the case. It's simply a difference in the systems that are applied in Norway and applied in their own country. So I think that's something that needs to be considered. And as to Ruth's question about the far right using this, from what I've been able to see, the far right anti-gender actors, they run with this no matter what country they're from, because Norway is an anti-example of their desired society. It is the example of a society gone mad, where you have the welfare state intervening in everything, run by gender ideology and then taking kids away from Christian families, etc. You don't need to go into more details, but they all find a unifying alliance around that. And then in terms of parental rights, very briefly, some of the areas in parental rights that Alliance Defending Freedom will be going into, they're contesting comprehensive sexuality education, that's clear. But one of the bigger things that they're going into is an attempt to privatize public schooling, okay? They're very much advanced in this respect in the United States. And they're pushing for this in a number of different European countries. And then along with this, homeschooling. So like this, we can put children in private schools run by religious authorities. And then in terms of alliances between feminist groups, reproductive health groups, and child organizations, that's something that still needs to be cultivated. I don't know if we need alliances so much, but we need to, everyone needs to realize that they're facing a similar problem. It's just affecting different areas of what they're looking at. But the source of the problem is the same. Thank you.
Thank you so much. Thank you so much.